All right, this is case number 254289FY, the people of the state of Michigan versus John Henry Burgess. We're here for an arraignment. Mr. Burgess joined us. Sir, are you able to see and hear the court?
I can, yes, sir.
And can you see me as well?
Yes, sir.
All right. I'm Judge Wiggins in the 84th District Court in Wexford County. I know you just met with Mr. Harrison. I have a complaint here that alleges that on or about June 30th, 2025 in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution has also charged you as a second subsequent, which means that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony and the $15,000 a $30,000 fine. Additionally, and in the alternative, they have elected to charge you as a habitual fourth offender. That means that you have at least 3 prior either completed or attempted felonies in your past. That makes that 10-year felony punishable by up to life. Now, they can only move forward on either the second subsequent or the hab. They can't try you on both. Do you understand that?
I understand. No, I don't. Well, yeah.
Okay, so if you went to trial, they would have to make a decision as to whether or not they were going to go to trial as a possession under the second subsequent or a possession as a hab 4. They can't do both. Does that make sense?
Yes, sir.
Do you understand the charges and the potential penalties?
I do, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I request an appointment of an attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a prelim. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Do you understand that?
Yes, sir.
Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. And my understanding, Mr. Burgess, is you're currently sitting a sentence with the Department of Corrections. Is that accurate?
Yeah, it's for possession of meth, my first one. I'm still on that. I'm still on my 8 prefix. I did 9 years on an 18-month sentence.
Okay. When is your potential release date? Do you know?
My next it's in July. I see the parole board again of 26.
July of 26. All right. Thank you. Mr. Harrison, any comment regarding bond?
I would prefer that the court set one to ensure that credit is properly allocated. Obviously, there's several layers to this onion.
On behalf of the people?
Your Honor, I would ask for a high monetary bond. I understand that he is sitting a sentence and not getting out anytime soon, but given the seriousness of the charges as well as the defendant's lengthy criminal history, I think it would be appropriate. I would also ask for random alcohol tests or random drug testing in the event that.
All right. The court will set a monetary bond, even though I realize it's an exercise of futility, but I will set a $25,000 cash surety bond with the conditions that he appears ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, I'm going to order that you not consume any controlled substances, including recreational marijuana, and you'll be subject to random testing for both. Anything else for the record, counsel?
No, Your Honor.
No.
All right.
I'm gonna ask him.
All right, thank you, Mr. Burgess.
All right, thank you.
All right, court calls the people of the state of Michigan versus Brittany Copenick, case number 253798 FY, appearances counsel.
Joanne Carey for the people.
Hey, please call Rob Champion hearing on behalf of Ms. Copenick, who is seated to my right.
And Mr. Champion, you're filling in for Ms. Firavento, is that correct?
I have actually taken the case.
You have taken the case.
Yeah.
All right. We are here for a probable cause, I'm sorry, preliminary examination. Is there any resolution in this case?
There is, Your Honor. My understanding, my client will be entering a plea of no contest to the lesser included charge of retail fraud.
Carrie?
My understanding, it's also my understanding that the defense is going to withdraw their charge of ordering for criminal responsibility.
But you're going to withdraw the insanity defense
Correct. Your Honor.
request. Is the value, is the retail fraud second based on value or a prior conviction?
It could be both on either.
So Ms. Copenick, have you heard what the attorneys have said the resolution in this case is?
I have,
And is that how you wish to resolve it?
I do.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
It's my understanding that you'll be pleading guilty to a lesser offense of retail fraud second degree, which is a 1-year misdemeanor. In exchange for that, the people will be dismissing the retail fraud first degree, which is a 5-year felony. Is that your understanding of the plea agreement?
Yes.
Now, additionally, this is a no contest plea, which means that the court is going to look at a document, looks like it's going to be a Michigan Department of State Police incident report to determine whether or not there's a factual basis to accept the plea, and I can use that for sentencing. Do you understand that?
I do understand.
And there's only certain reasons a no contest plea can be accepted. I'm sorry, Mr. Champion, the reason again?
Your Honor, due to her illness at the time, she does not have a thorough memory of it.
All right. And I recall from prior proceedings, there's maybe some mental health issues.
There is, Your Honor, and my client's currently under treatment.
All right. And so, Ms. Copenick, one of the reasons the court can accept a no contest plea is for lack of memory. So based on the previous hearings we've had and what Mr. Champion is representing today, I believe that a lack of memory is a good reason to accept the no contest plea. Back on August 24th of this year, were you on probation or parole?
I was on probation.
You were on probation. Have they violated you for this at all, Mr.
They
Champion?
have not.
They have not, and they're not going to, they're aware of this.
Okay, all right. Were you on bond in any other file?
No,
Do you remember reading and signing this advice of rights form, talk about your rights to an attorney and your rights to a trial?
I do.
Did you understand those rights?
I do.
Do you have any questions for me about those rights?
Not this time.
Most importantly, do you understand that you have a right to a jury trial, which, and we talked about this before, where 6 people sitting over there would decide whether or not you're guilty. But by entering a guilty plea, or I'm sorry, no contest plea, you'll be giving up that right to have a trial and you won't have a trial of any kind. Do you understand that?
I understand.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No,
Has anybody threatened you in any way?
no,
And is it your own free choice to plea today?
yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm aware of none, Your Honor.
I'm not.
All right, I've been provided with, which marked as, sorry, with People's Exhibit number 1, which is a Michigan Department of State Police Incident Report number 071-000-2762-25. Ms. Carey, are you moving for its admission?
I do.
Mr. Champion?
I am also.
People's 1 is received. Give me a moment to take a look at that. And do counsel believe that People's Exhibit number 1 forms a factual basis to accept the plea and the court rules been complied with?
I do.
I do also, Your Honor. Go ahead.
Counsel, I believe it makes out the retail fraud, but I'm not seeing where it talks about a because the value taken from Meyer is $140, so I think I gotta rely on a prior conviction. Is that listed in the report? I see where it says she was on probation, but I don't see where it says it was for a prior retail fraud.
It's that we show. So 369 and 238 should be attached to the report from.
I also have a prior convictions, Your Honor.
We have certified copies of those as well.
I apologize. It's in the statement from the asset protection. I apologize for that. All right. All right. The court agrees that the report with the attached asset protection report makes a factual basis to find the defendant guilty of retail fraud, second degree, in that on or about August 24th, 2025. Michigan State Police were called to a retail fraud at the Meyer store. They later make contact with the defendant, who returns the items, or at least some of the items, over to law enforcement. It does appear that there was over $200 taken. As such, I find the defendant guilty of retail fraud, second degree. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea due to the reported lack of memory. Are we able to sentence today, Ms. Carey?
Yeah.
I would ask the court to consider adjourning sentencing in this matter. My client's currently under treatment and is supposed to have additional testing that I can provide for the court. Sentence.
How long do you think that will take?
I would say 4 to 6 weeks.
I don't oppose that.
All right, we will set sentencing out for, we'll start with the 4 weeks, so we'll set this out for a month. Just make some notes.
So the court's where I received some information from the community mental health, but I expect to have more here.
All right. Is there any objection to the court holding the exhibit until sentencing?
No objection.
All right, Ms. Copenick, just a reminder that your bond conditions continue, okay?
Okay.
All right, good luck. That completes the docket.